Beaner Gringo, From Mexican Kid to American J.D. by ᴏᴏᴍ. Narrated by ᴏᴏᴍ. Chapter 1. Mexico. I have found that the short period between my birth in Mexico to my immigration to the U.S. left me with at least 3 lasting impressions about Spanish as my mother tongue and protection. After all, few parents would find odd the idea that young children are impressionable. This lesson from common experience has not evaded the decisions of the U.S. Supreme Court in significant cases, including Lemon v. Kurtzman, in which the court declared unconstitutional state statutes that gave state financial assistance to non-public religious schools as violative of the Establishment Clause of the First Amendment to the U.S. Constitution, and in which it considered the impressionable character of children in those schools, as in the following. This process of inculcating religious doctrine is, of course, enhanced by the impressionable age of the pupils in primary schools particularly. Citation: Lemon v. Kurtzman, 403 U.S. 602, 616, 1971. That is, early childhood can be a period in which ideas, feelings, or opinions about people, things, and the world can form without conscious thought or on the basis of little evidence. Similarly, the importance to a child of his or her mother tongue has not entirely escaped consideration in significant cases that make up the landscape of American jurisprudence, such as Meyer v. Nebraska, in which the U.S. Supreme Court held unconstitutional the application of a state statute that attempted to forbid teaching a non-English language, including German, to children before the 8th grade, under the liberty prong of the 14th Amendment of the United States Constitution. However, while the court found the means the statute constituted in relationship to the goals unreasonable, it did not oppose the goals themselves. These goals of the state legislature to promote English as the mother tongue of all children reared in that state rested upon reasons including that it is a well-known fact that the language first learned by a child remains his mother tongue and the language of his heart. The purpose of the statute is to ensure that the English language shall be the mother tongue and the language of the heart of the children reared in this country, who will eventually become the citizens of this country. Citation: Meyer v. Nebraska, 262 U.S. 390, 396, 1923. Thus, the importance of a child's mother tongue was not itself denied by Meyer. It was not denied that a child's mother tongue is susceptible to the formation of deeply held feelings. Deeply held feelings, as in my case, are also capable of arising from a child's experiences with the employment of serious and excessive physical maltreatment by his father. This common sense notion has been indicated as well by the vulnerability of child abuse victims that landmark cases in American jurisprudence have implicitly recognized, such as in Maryland v. Craig, in which the U.S. Supreme Court upheld against a challenge brought under the Confrontation Clause of the Sixth Amendment to the U.S. Constitution, a state statute that sought to prevent emotional distress to testifying children who had suffered child abuse, i.e., we likewise conclude today that a state's interest in the physical and psychological well-being of a child abuse victim may be sufficiently important to outweigh, at least in some cases, a defendant's right to face his or her accusers in court. Citation: Maryland v. Craig, 497 U.S. 836, 853, 1990. That is, acts of child abuse can leave the victim emotionally and psychologically vulnerable so as to justify the adoption of measures as significant as limiting constitutionally protected rights. Why then should it appear so very odd that a child who experiences acts of serious and excessive physical maltreatment by his father from a very young age should develop a sense of connection to the weak and vulnerable, as I have found to have happened in my case? I fail to find it so odd. Why should it be so very odd? In those circumstances, feelings and opinions in that child should tend towards a deep-seated drive to embody an autonomous source of protection against threats, as I have found to have happened in my case. I fail to find that it is so odd. Birth, parents, sisters. My origins are Spanish-speaking and not English-speaking because I was born in Mexico, specifically Ciudad Victoria, capital of the northern state of Tamaulipas, and grew up there. 2 years in Ciudad Victoria, 3 in Mexico City, until the age of 5. My parents were also born and raised in Mexico, my mother in Mexico City, my father in the northern state of Tamaulipas. They have always been primarily Spanish-speaking. See if you can imagine yourself in your first moment of memory. When I do so, I find that in that instant, I am in my family's home in Mexico City and in my white crib, which has been placed on my mom's side of the bed with my pudgy pink hand in my mom's hand, made available to me with a sense of traditional duty, reminiscent of the manner with which she set the table every day, 3 times a day, and busied herself serving the food or finishing up another chore or tending to my sister or me, so that I only saw her peck at a rolled up tortilla and some beans during meal times, until she picked up the plates when everyone else was finished with his or her meal. As my mom has since confirmed, for several years after my birth in 1983 in Ciudad Victoria, Tamaulipas, near my father's birthplace in the north of Mexico, it was impossible to get me to fall asleep unless my mom let me feel her small, soft, warm hand, sometimes for a half hour, sometimes less, sometimes more. But there's a darker side to my early memories in Mexico, like a stormy skies coming together with an earthquake and the feeling of stern shadows. My father. The only memory I have of that time with my father comes from the time in which I was already in preschool, because I was ultimately dressed up in a sailor's costume to participate in a parade at preschool. At that time I was seriously hit by my father at around 10 a.m. in the morning on the bed of my parents' bedroom. There was a bed in the center of the room. I was on it, a pudgy warm mass of sniffles with rosy cheeks due to a cold. There was my blue and white sailor's outfit laid out on the bed next to me for me to wear in the school parade that day at noon. There was my mom over by the bedroom door, her gaze apprehensively trained on the micro movements of my dad's facial features as she tried to convince him in her plaintive voice that I should not be made to participate in the parade. When my father snapped, I was hunched over. Suddenly I could feel it begin to hail blows, as if for an hour. I could feel his heavy hands, the jarring of my bones, the short-circuiting of my sensory system, as I found myself sent out and repeatedly returned to the feeling of being in the world. Then the delay between one blow and the next, then the instability of my body, and then a sense of suspension, and then the hard slap of the cold tiles of the floor against my palms as I landed, and then felt a shove of a shoe, until my mother finished saying for the last time, "Leave him alone already. Déjalo ya. You're going to hurt him. Lo vas a lastimar," and began to carry me back onto the bed. My father stormed off. A few hours later, my father took photographs of the school parade. There is one in which I appear alone with my sailor suit, rosy cheeks, and sad face. In contrast, my first sister in time, Dolores, often called Lolis in her native Mexico, and when you're older than me, did not hold my mom's hand to fall asleep. Neither did my second sister, US born and 7 years younger than me, hold my mom's hand to fall asleep. Chapter 2. Early Days in the USA. I have found that the initial period of my life in the US was arguably like a blueprint written in invisible ink. After all, in light of the previous chapter, why should it be surprising that a 5-year-old child could develop, as I find myself having been capable of doing, a sense of loss regarding his mother tongue upon finding himself uprooted from one day to the next from the pervasive sounds of his Latin mother tongue and transplanted for the indefinite future into the pervasive Germanic sounds of English? I fail to find it is so very surprising. Furthermore, it is not unknown that in some people amongst whom I find that I could be included, hope springs eternal. It is not unknown, and has even given occasion for humor on part of some California appellate courts. Thus, in County of San Luis Obispo v. Superior Court, a California appellate court determined that a party seeking relief under a mechanism known as a writ could not obtain it because he no longer had the required interest in the land at issue for relief to be available to him, to which the party had argued that he could reacquire that interest one day, eliciting the observation by the Court of Appeal of California, "Hope springs eternal, but writ relief is temporal and requires firmer substance." Citation: County of San Luis Obispo v. Superior Court, 90 Cal App 4th 288, 293, Cal App 2001. Moreover, why should it be so very odd that a young boy who finds himself, as I find myself having been, subject to extra privations, including in his early years, compared with those borne by his sister, when that differential treatment is not substantially called for by reference to his sister's sex, could go on to form feelings of intense dislike towards unjustified inequality of treatment in the future? I fail to find it so very odd. And in fact, this interest that even a boy could have in not being told reflexively that he is to carry greater burdens because of his status as a boy can even be found reflected in notable cases in the rich landscape of American jurisprudence, that often invisible source of why we are forced to not do this but to do that in matters ranging from buying groceries to buying homes. Thus, in Mississippi University for Women v. Hogan, in which the U.S. Supreme Court invalidated a state university's refusal to allow males to enroll in its school of nursing because the distinction made as to the applicant's sex lacked a sufficient relationship to the alleged reason of compensated for limited opportunities for women in nursing. Most nurses were women then. The court noted that this statutory policy discriminates against males rather than against females, does not exempt it from scrutiny or reduce the standard of review. The party seeking to uphold a statute that classifies individuals on the basis of their gender must carry the burden of showing an exceedingly persuasive justification for the classification. Mississippi University for Women v. Hogan, 458 U.S. 718, 723, 1982. That is, common experience and American jurisprudence are in sync with the idea that a boy does not necessarily have a lower interest than his sister in avoiding knee-jerk, sex-based reasoning for the imposition upon him of a greater burden than his sister. Furthermore, as I find to have happened in my case, why should it be so very odd that physical threat realized by a young boy's father upon the other women in that boy's immediate family could either lead those women to treat that boy too as a similar threat, even in the absence of any history of assaultive conduct by that boy, or lead these women to more than legitimately impose demands on that boy for conformity with with a standard of behavior governed by their resulting subjective preferences. I find that this happened in my case, but I fail to find it so odd. In fact, it is not odd either, in the light of the interest people are recognized to have in the vast landscape of American jurisprudence by sources that are widely cited in American jurisprudence as persuasive authority, including the Restatement Second of Torts. This source reflects the widespread recognition of an interest in preserving the inviolability of one's person, qualifying, however, that in cases in which no substantial or tangible bodily harm results, that interest is subject to a requirement of reasonableness and intentional conduct, as opposed to merely negligent conduct, i.e., the interest which one has in the inviolability of his person, and therefore in freedom from unpermitted contacts, which, while offensive to a reasonable sense of personal dignity, cause no substantial or tangible bodily harm, is an interest of dignitary rather than of material value. As such, it is protected only against intentional invasion. Citation: Restatement Second of Torts, Section 18. That is, it is not so very odd that the law should recognize and seek to protect people's interests, and thus it is not odd that those women should have an interest they could seek to protect in avoiding threats to the inviolability of their person. However, in terms of legitimate demands, they erred to the extent that they set the bar for that interest to be met as their subjective preference, irrespective of evidence of intentionality, instead of a standard based on reasonableness and intentionality in the absence of substantial or tangible bodily harm. Also, why should it be so very odd that in the face of those higher than legitimate exactions, as I find to have occurred in my case, that boy could develop the consciousness that his freedom could be subject out in the world beyond to higher than legitimate exactions reference to subjective preference? Also, why should it sound so very odd that such a boy could develop a corresponding consciousness that his rightful exercise of freedom might require the ability to articulate a defense of his rightful presence, as I find having happened in my case? I fail to find it so odd, not least because identifying the centrality that the home and the occupants of the home could have in connection to each other presents no earth-shattering act, where that centrality has been reflected since time out of mind in sayings such as "home is where the heart is." Further, the idea that the exercise of one's liberty need not be like a vane's turning on the direction in which the winds of others' subjective preferences happen to blow is not merely a common experience, but also one that is not foreign to American jurisprudence. Thus, in Wisconsin v. Yoder, in which the U.S. Supreme Court upheld an exemption of the Amish from certain compulsory education requirements under the Free Exercise Clause of the First Amendment to the U.S. Constitution, the court qualified that as a general matter, the very concept of ordered liberty precludes allowing every person to make his own standards on matters of conduct in which society as a whole has important interests. Citation: Wisconsin v. Yoder, 406 U.S. 205, 215-16, 1972. That is, it is not so very odd that a person could find himself subject to greater than legitimate exactions like those described above, and in turn find himself developing the consciousness that his freedom could be subject out in the world beyond to higher than legitimate exactions reference to subjective preference. Because what is odd is to find oneself in the U.S. with his or her rightful exercise of freedom not subjected to the impersonal rules of ordered society, but instead to subjective preferences. That person could understandably develop a corresponding consciousness that the exercise of his rightful liberty might require of him the ability to articulate a defense of it. Lastly, it is hardly a well-kept secret, to which I have found myself privy regardless, that the inability to speak English fluently can reduce the field of available employment to low-paying jobs, which in turn can result in a weak socioeconomic status, where a weak socioeconomic status can in turn limit access to educational and other resources. From church floors to kindergarten. See if you can imagine the following in light of your knowledge of the story so far. It feels as though only 2 days ago your 5-year-old Max was wandering about, as I was, at a sort of farmer's market. Your mom had referred to it as a tianguis. Vente van, vamos al tianguis. They're like a Mexican version of one of Shakespeare's weird sisters. An old woman with a shawl and wrinkled, leathery brown skin had been sitting roasting peanuts with her eyes on you, smiling her partly toothless gums at you. Placing some peanuts in your hand, she cooed at you in Mexican Spanish, inquiring into your mom's whereabouts. ¿Y tu mami, güerito? ¿Quieres venirte a casa conmigo, güerito? Then you had felt your mom's small feet and voice behind you, as she diplomatically got the woman to leave you alone in Mexican Spanish with the white lie. No se moleste, señora. Al niño no le sientan bien los cacahuates. Vente, Iván, que tenemos a tu abuelita esperándonos. Your mom then warned you in Mexican Spanish that you could be kidnapped if you talked to strangers. And notwithstanding the threat she spoke of, you felt reassured by knowing that your mom knew about it, and that your mom had made you know about it in Mexican Spanish. Iván, no hables con gente desconocida. ¿No te das cuenta que secuestran a los niños para luego exigir un rescate? But today it feels like 2 days have passed since then, and American English and its concomitants displaced familiar airs and walls of Mexican Spanish in a Greyhound bus station in Riverside, California, loudly, roughly, grotesquely upon the ears, the way gargoyles would probably sound if they could speak. Excuse me, what'd you say? Oh, food? Well, there's a hot dog vendor over there, so you can go there to get some food if you're hungry. Phone? Oh yeah, there's a payphone just over there, ma'am. feeling butterflies in my belly. I had never seen my parents' dignified heads bow and their faces smile subserviently as often as they did now, after repeating, "Yes, thank you," as if before royalty. Fast forwarding a bit, however, it felt like those familiar walls or the air were restored when I met my kindergarten teacher, Ms. Hernandez, on my first day of school. On the first day of class, I silently watched from the safety of a bench at the school entrance, the bulky forms of students streaming past me with big backpacks. When Ms. Hernandez